All right, and we are live.
Yep. Good afternoon, everyone. This is the House Energy Digital Infrastructure Committee on February 12th at 1 p.m. We're going to go around the room and introduce everybody. We're waiting for the chair to return. She should be back. Oh, there she is. Okay. Anyway, I am Scott Campbell from St. Johnsbury.
Richard Bailey, Lamont 2. Chris Morrow, Wyndham, Windsor, Bennington.
Michael Southworth, Caledonia 2.
Christopher Howland, Rutland 4.
Jared Torrey, Washington 2.
Graham Kleppner, Chittenden 13, Burlington.
Representative Kathleen James from Bennington 4. And Rep. Sibilia.
Laura Sibilia, Wyndham 2.
Great.
Jack Locker, Committee Assistant.
All right. And folks in the room.
Hunter Thompson, Director of Telecommunications for the Public Service Department.
Great.
Lynn Zaka, here on behalf of the BCBB.
Maria Royal, Office of Legislative Counsel.
Will Brosman, Chamber of Commerce.
Madge Julius, intern at Montgomery General.
Great. Okay. Here we are. Scott, you already did the intros?
Just that fun.
Okay, great. All righty. So let's see. It's Wednesday, February 12th.
We did that one.
We did all that part. Okay, great. All right. So we are here to walk through H11 with Legislative Counsel. So for the record.
For the record, Maria Royal with Legislative Counsel.
Maria, you have, let's see here. So we have about half an hour or 40 minutes, but we're with you all afternoon. Great.
Sorry about that.
No, that's okay. So then just a couple comments or requests, if that's all right. I think it is really helpful when we're doing a bill walkthrough to start with the actual current statute. So not to double your work, but to actually, if it's okay with you, pull it up on the screen, show us where we are, show us where we are in the vast universe of our state statutes and what we're tinkering with here. I just find that to be really, really helpful, to say this is where we are in the statutes. This is the broader bill that, section of language that we're working within. This is what that section does. And then we can talk about how we're changing it. Is that okay?
Yeah, that's
I
perfectly
think
okay.
it's super, super helpful.
Yes, I agree, particularly in this context. So I'm happy to do that.
Okay, great.
So this bill H11, there are actually two components. The first part is broadband consumer protection and competition. The second part has to do with VoIP service and ensuring VoIP service availability when there are power outages. And that'll come at the very end.
Okay.
With respect to broadband consumer protection, you'll notice right away, section 1, it refers to chapter 63 in Title 9. Title 9 regulates commerce. Chapter 63 is Vermont's Consumer Protection Act. And this is adding a new subchapter that has very specific provisions related to the business practices of the broadband providers in the state. The language is very similar to language that applies to other industries or sectors or practices in the general business laws of the state. Is consumer protection. So there are instances in Vermont law where you regulate specific sectors under consumer protection. Propane is one that often comes up. The Vermont Attorney General's office has authority to regulate propane dealers with respect to their practices. That issue sometimes comes up with respect to removal of propane tanks, right? It's a competitive market, as you know, not regulated by the PUC. The idea is consumers have a choice. And so ensuring that there are adequate protections for consumers. So if they want to terminate with one dealer, go with another dealer. That's just to give you an example of some of the types of regulations that exist that might apply to other businesses, right? But if there are laws of general applicability, although this new subchapter is specific to broadband service.
Okay,
So the Consumer Protection Act is enforced by the Attorney General's office, as well as state's attorneys, as well as private individuals. There's a private right of action for violations of the Consumer Protection Act.
okay. So I will just say to all of us, I know I'm gonna do this. I just find this to be so useful. When you get a minute, go to Title IX, if you haven't already, Chapter 63, and you can see all the links that are our broader consumer protection here in the state of Vermont. So you can see evidence of fraud, telemarketing, regulation of antitrust, assistive technology, children's product safety, lead and consumer products, third-party discount membership programs. So we are within a really broad section of our statute that deals with consumer protections across a lot of different industries, and we are looking to add a section on broadband. Okay, I just that's where I'm always coming from. Let's start at the very beginning.
And it's actually great that you're underscoring that point. I think it's been generally recognized in the courts and even by the FCC, different administrations, that the states retain some regulatory authority over consumer protection, unfair business practices with respect to the broadband industry. The question is, how broad is the state's authority? And when might the state infringe upon or unconstitutionally burden interstate commerce? So there are legal issues, but I think understanding that the state does have residual authority to exercise its police powers in the interest of protecting the public, and particularly consumer protection and business practices. I think everyone agrees there is some authority. I think everyone might disagree on where that authority rests or how broad that authority is. So I think that was actually important to point out why it's placed under Title IX as opposed to under the Public Utilities Commission.
And can I ask one more question?
Of course.
So I'm looking at subchapter 10, credit protection for minors. Am I looking in the wrong place?
This is 10A. So it's a whole new subchapter. It doesn't exist yet.
That goes between 10 and 11?
Yeah.
Is that so it would go between credit protection for minors and pregnancy services centers?
Yeah, and
Okay.
there actually is, if you ever want to do a summer project, the renumbering of the subchapters in this chapter and all the section numbers, that's why it always seems a little bit weird.
Okay.
And that's why it's, for example, the first section is 2490, the second section is 2490A, as opposed to 2491, because we run out of numbers.
I see.
so
We're
it's-
putting it in where the numbers are.
Yeah.
Representative Kleckner was talking to me earlier today, and he's going to be working on that this summer.
Really? Yeah, okay.
Thank you.
He's gonna be working with Rick on that, I think. Rick does consumer protection.
Yeah, Madam Chair told me she had secured a large amount of grant money to support that process.
I'm just kidding. All right. So we're looking for a place that has empty numbers.
Pretty much,
Okay, here we go.
pretty much.
Thank you for that.
So, and let me just ask you, how much of a line by line, do you want? I mean, it might be helpful. I leave it up to you. It might be helpful. There are very specific findings that I think kind of lay the groundwork. Representative Sabili can speak to that as well as the sponsor of the bill, but it might be helpful to go through each one. But I know you have different time limits and committees have different preferences and how, but so we can kind of do a real thorough line by line walk through. So you're familiar with all of the provisions and the supporting findings. So is that,
Yeah, I
does that work?
I gave the broad already.
think so. Yeah. Okay.
So, there is a proposed title for this new subchapter. This subchapter shall be known and may be cited as the Vermont Broadband Consumer Protection and Competition Act. There is a purpose section The purpose of this subchapter is to promote a thriving broadband market in Vermont, free of anti-competitive, unfair, deceptive, or misleading practices in order to protect the public and to encourage fair and honest competition. In terms of the findings, these are proposed legislative findings. First, the General Assembly finds that broadband is a critical sector of the overall Vermont economy. Second, broadband service is essential for supporting economic and educational opportunities, strengthening health and public safety networks, and reinforcing democratic, social, and civic engagement, and for allowing Vermonters to benefit from new and innovative internet-based products and services such as smart home, energy-saving technologies. The committee is familiar with. 3, despite considerable public investments in broadband deployment and service, about almost 15% of Vermont locations, which is about 47,000 locations, do not have access to high-speed broadband service. Many more do not have access to service from more than one broadband provider. 4, Vermont is a rural state with many geographically remote, sparsely populated locations with no or limited access to public transit systems. 5, those who live far from a town center or regional commercial hub are particularly disadvantaged by the lack of broadband access. They are burdened with the additional time and expense of traveling great distances to either access a broadband connection, such as a public Wi-Fi hotspot, or to physically carry out activities they are unable to do from home, such as online banking and telehealth appointments. 6, the critical need for broadband service, coupled with the lack of competition, particularly in high-cost areas, creates an imbalance of power between the provider and the consumer. 7, the Attorney General, as the chief law enforcement officer in the state, must provide a strong presence in the broadband market and protect and advocate for Vermonters when necessary. Getting close to the end. 8, all policymakers, law enforcement officers, and regulators must work collaboratively to ensure the market is vibrant, efficient, and competitive and serves as an engine of economic growth and innovation in all 4 corners of the state. 9, no broadband provider should be permitted to exploit its market position to stifle competition and deprive the consumer of a meaningful choice among broadband providers. 10, monitoring the broadband market through data collection and analysis will enable state government to identify and respond swiftly and appropriately to market failures or misconduct and promote a healthy economy. And finally, 11, a well-functioning broadband marketplace will foster competition, higher wages, lower prices, better service, more consumer choices, further investment, and increased innovation and entrepreneurship.
And for new members, findings, which some bills have and some bills don't, are just sort of a statement of, how do you want to describe findings?
So you're right. Not all bills have findings. They are legislative findings. So they're findings of fact
Right.
that you as the body make. So if any of these don't seem accurate to you, you're of course free to amend them, change them in any way that you want. I think in this context, like similar broadband bills in the past, findings can be very helpful in the event of a legal challenge, because what you're doing is clarifying for any reviewing court what the rationale is, why the state acted if you choose to act, and the determinations that you made. So given kind of the constitutional preemption, the issues that are always come up in the broadband realm, I would advise having findings, whether they're these findings or other findings. That's
Great.
up to you.
Okay, thank you.
So there are some definitions, and they're pretty much what you would think they are. So I'm not going to, I don't think I'll read them word by word, but just to clarify, broadband providers, you're talking about those who provide service to a person in Vermont. Broadband service, this essentially mirrors kind of the FCC definition of broadband service, and it includes basically all types of service except for dial-up service. I think we've kind of talked about that before. And then in terms of a consumer, when that's referenced throughout this subchapter, it's a person to whom a broadband provider sells broadband service. So those are the kind of the three, or the two entities and the one service that's referred to throughout. So the very first section of the bill or substantive section concerns net neutrality. Under current law, as of 2018, one caveat, in 2018, Vermont enacted a law that requires all state contracts. So when the state entity is buying internet service, the legislature, BGS, is acting as a consumer or a market participant. There's a requirement that any provider comply with the net neutrality requirements, right? That's no blocking, no throttling. You can't impact access to content or prioritize content. So this whole net neutrality debate, and I think we talked about it before, this has been an ongoing issue about whether governments should regulate net neutrality at the federal or state level. What's proposed here is, let me just back up. Vermont enacted its law. It's a very narrow law. There were a lot of proposals in states concerning the regulation of net neutrality. This was after the FCC's net neutrality rule was repealed. So there was a lot of activity at that time. Vermont's approach was pretty narrow. However, it was subject to a lawsuit, the name of which I cannot remember. That lawsuit was stayed pending the outcome of other litigation. That other litigation, and I'm sorry if I'm getting too technical or in the weed, concerned a law in a case that we're going to talk about in relation to the New York price regulation, affordable broadband. That was challenged in court. It was reviewed by the Second Circuit last year, 2024. I think in the spring of 2024, the Second Circuit held that that law was constitutional. At that time, the plaintiffs that had sued the state under its more narrow net neutrality law withdrew their claim. So that case has ended. I just wanted to kind of clarify that in case you hear a little bit about what's happening. So right now there's just the requirement for government contracts. For any provider who wants a contract is willing to comply with net neutrality requirements, and there's a certification process that's referenced here in Title III. It's through the Secretary of Administration. So it spells out what that means to comply with net neutrality, all the things I just said. So what this would be doing is saying if you want to provide service in Vermont, you agree to comply with net neutrality requirements. All Vermonters, businesses, residents. Yeah.
So right now, it applies the net neutrality applies only to state agencies
In Vermont.
that are contracting with an ISP. So this would broaden it to apply to all consumers.
Yes,
So it's a significant broadening of
absolutely.
net neutrality, because right now it's just if state agency is contracting with an ISP, they have to get a certificate of net neutrality. This would say, we're not just talking about state government, we're talking about this is going to apply to all of us.
Yeah.
Okay.
And
I'm just gonna ask, I don't know if you said this, but is the reason why the Secretary of Administration providing that compliance is because they do that for the state government? Or
yes, well, yes, they do a lot of the procurement contracts, and there's the bulletin having to do what the requirements are. there are separate areas that refer for the judiciary, for the legislature, that refer back to the Secretary of Administration, that certification, so that it was just decided that Secretary of Administration,
Something they do already, so.
Yep.
For
general
pick up
business
that-
practices, yes, state contracting. Yeah. The only other thing I wanted to mention while we're here concerning net neutrality, so again, back in 2018, I told you, what we just discussed what Vermont does. California enacted a law very similar to this, requiring net neutrality for all providers that provide service in the state of California.
Is California the only other state that applies net neutrality broadly to all consumers at this point?
That is a good question. I'm not certain if other states since then, if they were immediately sued. And ultimately, the Ninth Circuit in, I wrote it down here, I'm just trying to figure out the year. I think it was in 2022, held that it was a ruling on a preliminary injunction. The lower district court, the plaintiffs, industry trade associations basically sued the state. A lower district court judge on a motion for preliminary injunction to enjoin this implementation of the law held that they were not likely to prevail on the merits. It went to its appeal to the Second Circuit Court of Appeals, which ultimately affirmed the decision of the lower court and found that they were not likely to prevail on the merits. More specifically, so the arguments that were raised in that case had to do with preemption, which you hear all the time in the broadband world, whether the state of California was preempted from doing just what you're proposing to do here because it conflicted with FCC policy or specific provisions in the Communications Act. And they also argued that under this whole rubric of the Communications Act, it evidenced that the FCC had that occupied the field of broadband regulation, and that for states to do something that they were supposed to do in California, that was preempted. Those arguments were unsuccessful in the Ninth Circuit. So the Second Circuit is where Vermont is. So the case I referenced earlier about the New York law, Vermont is in the Second Circuit. We're bound by whatever the Second Circuit holds. Ninth Circuit, I would say it's persuasive and certainly relevant, but whether other circuits would agree with that holding, whether the Second Circuit. Yeah.
Okay. Yeah.
Do any current providers, land-based or satellite-based, have this net neutrality compliance yet?
I'm so glad you mentioned that because it was the one other thing I was going to say. There is, I don't know the answer to that, but there is one other law that relates to network management practices that was enacted, I think, in 2018. That requires all providers in the state to file their network management practices with the Attorney General's office. The Attorney General then posts all of that information on its website. And so they're actually, if you go to the AG's website, you can go through every provider in the state and see what they're, so I haven't looked at all of it, but part of the thinking behind that was consumers need to know and comparison shop. And that would be an easy place to be able to go through and get a sense of what different providers offer in the state. So I actually don't know what they're.
Okay.
So then there is a list of prohibited practices. And we'll go through each one of these. So all of what I'm about to read in these various subdivisions, starting with 1, are deemed to be unfair or deceptive acts or practices in commerce in violation of 2453 of this chapter, which is the general provision that says you shall not engage in unfair business practices And all of the enforcement investigation mechanisms of the chapter apply to those violations. So this is saying what we're about to go through fall within that prohibition of the chapter. So it's unfair for a provider to engage in any of the following conduct. And we'll just read through each of these. 1, failing to provide a consumer with broadband service that meets or exceeds the performance characteristics offered and sold to the consumer's service location. Failing to reimburse a consumer any installation costs associated with broadband service that is discontinued by the consumer because the service did not meet or exceed the minimum performance characteristics offered and sold to the consumer service location. 3, engaging in marketing or promotional practices that misrepresent the actual terms and conditions of a broadband service plan or tend to mislead or deceive an actual or prospective consumer. 4, imposing excessive termination fees or other burdensome conditions that unfairly restrict the consumer's ability to discontinue service or purchase service from another provider. 5, charging equipment or service fees that do not reasonably correlate with the cost of the broadband service or equipment provided to a consumer, excluding any state or federal fees. 6, failing to submit broadband availability data in a form and manner prescribed by the Department of Public Service for the purpose of maintaining the state's broadband availability maps under existing law. 7, violating privacy, security, or network management practices applicable to its broadband service. So if it violates its own terms of service. Or finally, 8, imposing a predatory data cap as further defined in subsection B. So I'm just gonna go through this last subsection, and I believe that is the end of the prohibited act. So what is a predatory data cap? That is defined in subsection B. A broadband provider should not impose a data cap except when tailored for the purpose of reasonable network management, such as managing network congestion. For purposes of this section, data cap means a limit on the amount or bits or other units of information a broadband consumer may download or upload during a period of time specified by the provider before the consumer is charged a fee for additional usage, is subject to an increasing cost per bit or other unit of information, is charged for an incremental block of usage, experiences a reduction of access speed, or is otherwise discouraged or prevented from exceeding that data cap.
So would this allow tiered pricing by cellular providers based on the amount of data used?
I think the issue here, tiered pricing with reasonable data caps. So providers can have tiered pricing, different levels of service. Right? You buy different levels, you pay more for higher speed. As long as it's non-discriminatory, there aren't particular providers that are favored, they're generally available, then you're offering that service. Any other, as I read this, any data cap that's not related to the capacity or bandwidth of the service, that's just for monetizing revenue, that would be prohibited.
Yeah.
Thank you. Does B conflict with 1 at all?
Just one.
Failing to provide consumer broadband service that meets or exceeds.
Well, I think B would say you can't offer data caps, credit, right? So you wouldn't be able to, you wouldn't be liable for exceeding a data cap that you're not allowed to have. I think so I don't think there's a conflict.
Yeah, it just with this, such as managing network congestion, that says to me that they can arbitrarily manage that by enforcing a data cap. Am I correct in that?
Say that again, they can arbitrarily
Enforce a data cap to manage network congestion. Am I understanding that?
No, you're right.
Okay.
And as long as that is part of the performance characteristics that the consumer is aware of and understands, then that's not a problem.
Okay.
And so, there has been some litigation on consumer protection of providers not meeting the service or misleading the consumers. I know in New York, there was litigation. I found the state had the authority to enforce general consumer protection laws for situations like this, where there is engaging in unfair business practices. Also, the termination fees, we already talked about, how that might apply in different contexts. I'm just trying to kind of flesh out other areas of law. There are provisions under Title IX that concern predatory pricing. You're not allowed to, for the purpose of harming competition, charge predatory prices. There's a provision that concerns price gouging. If there is some kind of market emergency, and that would apply to fuel dealers, gasoline providers, that you can't take advantage of that situation and charge burdensome prices. So I think all of these are pretty consistent with provisions that you have in law, whether they're appropriate for, that's for you to decide, and what the impact is. Again, that's for you to decide. But I wanted to mention some other provisions of law that were considered when drafting the specific language. And then with respect to consumer complaints, right now, and this would probably be a great area to hear directly from the Attorney General's office and the Department of Public Service, because they both have their own consumer complaint arms. And in the past, at least, there's been kind of a working agreement or understanding of who enforces what, or who refers complaints to whom and under what circumstances. For example, I think at least how it used to work, if the AG's office got a concern about broadband, immediately referred it to Department of Public Service. If it became apparent that it was more of a consumer protection issue, it was then referred back to the Attorney General's office. So having an understanding of what the dynamic is now might be helpful. What this is proposing to do is to basically create one location in state government, so that all consumer complaints related to broadband are collected in one database. So I'll just read subsection A. For the purpose of creating a single location within state government for the receipt and tracking of consumer complaints regarding broadband service, the Attorney General, in consultation with the Commissioner of Public Service, shall establish and implement protocol for handling complaints. The protocol shall include a process for maintaining a database that aggregates and tracks the number, nature, disposition status, and resolution time of complaints received directly by state government and indirectly from provider records submitted to the Attorney General under subsection B, which is what we are about to read. Much of what we're getting into now concerns having one entity, in this case, it's the Attorney General's office, monitoring what's happening in the market, both with respect to consumer complaints and market trends generally. Where is service available? Do consumers have a choice? Is there any kind of monopoly disadvantage where consumers aren't able to adequately protect themselves? And might the AG want to step in, or should there? So we're kind of moving into the supervision portion of the bill.
May I, I'm gonna pause for one moment. Representative Karen, we are running a little bit behind. which is entirely my doing. So, I just wanted to give her an estimate on when to come back. What do you think?
A minute.
Oh,
No, I'm kidding.
okay.
No, maybe like,
2,
sure, 2:00.
sorry, Kate.
No, that's.
Yeah, okay. I didn't want to waste your time.
Thank you so much.
You bet. Okay.
Okay, so there are a couple of reporting requirements that apply to broadband providers. This is one of them in subsection B. And this is specific to complaints that are received by the companies. And so it states that beginning January 1st next year, the provider shall maintain a complete record of any consumer complaints received regarding its service. The record shall include total number of complaints received, the nature of each complaint, the disposition of each complaint, the time it took to process and resolve each complaint, and any other relevant information requested by the Attorney General. The provider shall submit a copy of the record of complaints for the preceding year to the Attorney General beginning on January 1st of 2027. To start collecting next year and then start reporting the following year. And then just a definition of complaint means any communication primarily expressing a grievance. So getting more broadly into monitoring of competition within the broadband industry. Section 2490G specifies that the Attorney General shall routinely monitor current and emerging market trends and business practices in the broadband sector and assess their effect, positive or negative, on consumers, workers, businesses, and the broader Vermont economy. And the factors to be considered by the AG shall include the number of providers actively engaged in providing service in Vermont, market share, ease of market entry, so new businesses, industry consolidation, and any other factors the Attorney General deems relevant to a market analysis. And then C, the AG shall periodically review and compare a provider's broadband consumer label for multiple service locations in the provider's own market area. And then there's a reference to what a broadband consumer label is. The FCC requires all providers to prepare a broadband label, which is similar to a nutrition label. And actually, I brought
What is it? I don't know.
copy.
Okay.
Yeah, because I
You were prepared, yeah.
I thought that might come up what that might actually look like, because it really does look like a nutrition label. Question is going to be, can I find it in a reasonable amount of time?
That's it.
Yeah.
So is it in a pack of stuff? I will read that.
So again, this is now required by the FCC for all providers, and they need to provide it at the point of sale, whether it's online or in a store. And the intent is that all consumers can see very clearly what the terms of the service are, what the prices are. Because there's a lot of concern about people sign up, there are these teaser rates, and then they don't fully maybe understand that the rate's going to go up in a year, or service might not be what they thought. So I'll give you an example. So what's on here, the monthly price, is it an introductory rate, the length of period of the introductory rate, the rate after the introductory rate, the length of the contract itself, a link so that a consumer can easily find the more specific terms of the contract, and then any itemization of all of the monthly fees, if there's a modem rental, a Wi-Fi extender, one-time purchase fee, installation costs, battery backup fees, early termination fees, any government taxes, like the federal and state universal fund fees, and then a description of any discounts or bundles, the speeds that are provided to the consumer with the plan, upload and download, any latency characteristics, the data that's included with the monthly price, their network management practices, which is, the bandwidth controlling that we talked about earlier, the privacy policy, a link to their privacy policy, and a number for customer support.
Can you pass that around?
So, yeah, I'm sorry, I should have brought more copies.
That's
but
all right. So when you sign up for a service, that's somewhere in the stuff?
It should be,
Okay.
it should be.
Yeah, Victoria.
Would minimum performance standards fit there? Or are they in that upload?
They would be on here. So like speed requirement, the speed would be on here.
Okay.
Yep. And so,
Sorry.
no, please.
Madam Chair.
Yeah. Oh, sorry, I didn't see you.
So back on the, who would enforce the accuracy of their submitting the information, about the consumer complaints? And if they're found to be incorrect, what happens then and who enforces that?
Yes, so there is another provision which we're gonna get to, and I think it references back to this
Okay.
complaint reporting that specifies, I think it has to, I don't know if it's sworn under oath, I actually can't remember, but it addresses that very issue.
Okay.
So maybe pause
Keep going.
for a
Keep going.
second, okay, and then we'll make sure, remind me,
Yep.
to refer back and see if it encompasses the complaint report. So subsection D says the AG shall review provider business practices, including data practices, as appropriate to determine whether any practices negatively affect marginalized or underserved communities or worsen disparities and inequities in the social and economic fabric of our state. And then the subsection E, to assist the Attorney General with carrying out the purpose of this section. So now we're getting to another reporting requirement on broadband providers. An annual reporting requirement that they need to begin on October 1st of 2025. The following information relating to its provision of fixed broadband service. So this only applies to fixed broadband service, not mobile cellular broadband service. To only can be wireless, can be wired to a fixed location. So those providers that have those subscriptions in the state need to file the following information, which I'm going to go through now. And again, this is all information that goes to the Attorney General to understand the market and what's happening. So the total number of active broadband service plans the provider has in the state, the total number of active wired broadband service plans categorized by the technology used to deliver the service, whether it's DSL, coaxial, fiber, or hybrid fiber coaxial, the total number of active wireless broadband service plans categorized by the technology used to deliver the service, whether it's terrestrial or satellite, and whether the service is supported by licensed or unlicensed spectrum or both. The median and mean price, download speed, and upload speed of its active broadband service plans in Vermont and within each county, if applicable. The number of years the provider has been actively engaged in providing broadband service in Vermont. The broadband availability data that's submitted to the Department of Public Service, which is their mapping, and subscription data that is submitted to the FCC under its broadband data collection system. So a lot of information is submitted to the FCC. This is just ensuring that so that the FCC can monitor the market, the national market. So this is just specifying that this data shall also go to the Attorney General in Vermont so that the AG can monitor the market. Again, because the AG has Consumer Protection Authority and also enforces the antitrust laws necessary. And then any other information deemed relevant. So this report shall be submitted in a form and manner prescribed by the Attorney General. And then I think we're starting to get to some of the questions that were just raised. It is unlawful for a provider to knowingly or recklessly make or cause to be made in a report submitted under this section a statement that at the time and in light of the circumstances under which it is made is false or misleading in a material respect, or is false or misleading due to the omission of the material fact. The accuracy of the information included in the report shall be verified by oath of two of the provider's executive officers under penalty of perjury. And then just a clarification of what recklessly means under this statute. It means consciously disregarding relevant facts. So what I was looking for is whether this encompass the complaint report, and maybe there should be some kind of tie back that those same provisions might also apply to the complaint report. But
I would leave that to you.
I'm gonna leave it to you all.
Yeah. Are you, Rep Southworth, are you making a note of that? Or somebody making a note? I did not make a note of that.
I
Okay,
made a note of that.
thank you. Someone make a note.
Are we in time? Okay, so transparency. So just in general, I'm gonna read through this section real fast. And then I'm gonna talk about it. So as I mentioned, there's an existing law that requires the providers to put their network management practices. That's repealed in a later section, and instead, this is the new proposal. This is a new law that's very similar.
Gotcha.
So to facilitate informed consumer choices, a provider shall submit to the AG its current policies and practices regarding network management, security, and privacy. Information is submitted in form and manner prescribed by the AG, not less frequently than annually. And then the AG aggregates and discloses the information on a publicly available, easily accessible website maintained by its office. I think one of the things that all of the different commissions, federal communications commissions, different administrations seem to agree on is transparency. And that is the opportunity for the consumer to make choices about whether they want to go with a particular provider or not. Right? There's a transparency rule about all of the disclosures that a provider must make. And so that's part of what the broadband label was about, ensuring that all consumers understand what service is available to them. The greater transparency, the greater understanding, the more a consumer can make an informed choice about which provider they would like to go with. It's an issue if you don't have a choice of providers or you don't have a provider. So that's kind of the whole market analysis. And again, this is all consumer protection. To keep Vermonters connected, they can go through this pretty quickly. This basically says at the time, if there's a state of emergency, like there was with the pandemic, an all hazards event, which could be a natural disaster or it could be a disease related event like that, like COVID. That providers are prohibited from disconnecting any consumer from service, charging unconscionably high prices, which is later defined, or imposing data usage limits at all during a declared state of emergency. During the pandemic, the FCC under then Commissioner Chair VPI had the Keep Americans Connected initiative, which was not a requirement, but basically asking all providers to pledge that during COVID, they would not disconnect people if they were unable to pay their bill because the people lost work and lost wages, et cetera. So there was some eligibility stuff, but basically what was interesting about that is at that time, because the FCC at that time had already reclassified broadband as an information service, not subject to its great regulatory authority. It didn't have the authority to require that providers. So they asked the providers take a pledge during COVID, and I think most of them did. I think like over 800 providers. This is more specific. It's not a pledge. It's not voluntary. It's specifically saying that if there's a state of emergency, you cannot disconnect somebody if will cause financial hardship, and if there is a financial hardship on a person caused by the all hazards event. There's a similar provision in Vermont law with respect to water and wastewater utilities. If there's a state of emergency, no disconnections. And so just to clarify what an unconscionably high price is, if there is a gross disparity between the price charged during the emergency or 7 days prior to the emergency and the price at which the same service was sold or offered for sale in the usual course of business immediately prior to the state of emergency, and the disparity is not substantially attributable to increased prices in the wholesale market or increased costs due to the state of emergency. So this particular definition, I believe, was taken from an existing law that concerns price gouging by motor fuel under consumer protection if there's some kind of market emergency. So you're not taking advantage of consumers. This is a reference to the investigative and enforcement authority of the Attorney General, similar to other provisions under the Consumer Protection Act. And again, just specifying that any violation of this constitutes a violation of 2453 of this chapter, which is the main general prohibition. Interagency cooperation, this is, I realize we're getting pressed for time. So this is just allowing or specifying that the AG shall work with other entities in the state, Department of Public Service, the Vermont Community Broadband Board, Department of Taxes, ACCD, so any state entity that has overlapping jurisdiction. And the hope is that this model that you should hear from everybody kind of draws upon the core competencies of state actors, but that they all work together to take informed actions. There's no waiver of any privilege or protection that's afforded any information under this chapter. So if it's confidential information, it remains confidential information. The assessment provision, this allows the AG to assess any costs of complying with this subchapter against broadband providers on an equitable and practical basis. And that rate shall be adopted by the formal rulemaking process. This is very similar to an existing law that concerns property and casualty insurance and rate regulation. In Vermont, the property and casualty market is presumed to be competitive, but the Commissioner of Financial Regulation monitors and reviews the market all the time. And there's a similar provision that allows the Commissioner of Financial Regulation to collect an assessment. This is just saying that any information that the AG has, if it's confidential, it remains confidential. Then just a requirement that there's an annual report from the AG to you, to the General Assembly, that any findings and recommendations that the AG has regarding competition in the broadband market and whether and to what extent anti-competitive conduct or unfair deceptive acts or practices are occurring. So just a summary of market monitoring data, summary of the complaints, summary of any assessments collected and charged, any description of any enforcement actions, and any recommendations for improving conditions in the broadband market.
Yeah, so that assessment piece is why there isn't an appropriation for this.
That is correct. I think the one thing that, so as I mentioned, this is similar to an existing law. It's similar to like basically a bill back provision. And there are other instances where for particular proceedings, the PUC can bill back to, utilities during an investigation. There are other more specific provisions related to financial institutions. If there's an examination or investigation where you can bill back the cost of that. I will have to say, even though this is an existing law, I think it raises the question of how much authority do you want to delegate to the Attorney General. It is through rulemaking, so there's an official rulemaking APA process, which involves public input and so on and so forth. But I always get a little bit nervous when you don't know exactly what the fee is and you want to just monitor what. So I think that, yeah. Okay, this might be right for discussion. So rulemaking authority, effect on other laws, doesn't limit other statutory rights. It's interpreted liberally. It's remedial in nature. The provisions are severable. So if there is litigation, particular provision is found to be unlawful. The other provisions were named, a reference to the state's authority under the 10th Amendment, police powers of the state. We talked about the repeal of that existing network. Yep.
I think Representative Bailey has a
Oh,
question.
sure.
Yeah, following up on Rep. Torrey's question. He looks at this and this, will they come back to us and say, I need another person for this?
They might.
We're gonna take testimony from them.
Okay.
So those are the broadband consumer protection provisions. And then this is the next topic that's addressed here again concerns VoIP service. This was the issue about emergency preparedness. A lot of people who have VoIP service don't always understand that during a power outage, they might lose their ability to make telephone calls if they don't have any kind of battery backup, right? It's all over the internet. It's not line powered like the traditional copper telephone lines are. So, and there have been a number of concerns. There have been studies, and this issue has been looked at. There's also reporting that goes on between the providers, their outages, and reporting to 911 so that 911 can keep track of the particular vulnerable areas that we need to pay attention to. But basically, this is establishing a program. It's the Commissioner of Public Service to review quarterly the outage reports that are submitted to 911, looking to see if there are particular areas that are prone to outages, and whether those areas have access to other fixed voice service, so a copper telephone line, for example, or mobile service. And then to establish a process for receiving an annual statement from each VoIP provider, certifying that they do comply, they are required to comply with FCC regulations. And I believe now they're required to have battery backup power that lasts for 24 hours. So this is just ensuring that that's happening. And then another consumer complaint provision, just keeping track if there are any subscribers to VoIP that have concerns, and also developing consumer education, community outreach to ensure that people understand how to be prepared in the event of an emergency and a power outage. And finally, make recommendations to you about any further steps that are necessary, and work with the other state actors involved in preparing the program, developing the program. Well, that is the entirety of the bill.
Thank you. So I want to respect Representative McCann's time. So I will just thank you, Maria, and then just to let our committee know. So this is a big bill. This is not just for context. So we are going to be hearing later this week on this bill from the Broadband Board, from the Department of Public Service, from the Agency of Administration, and from the AG. So, and then at that point, I think we'll make a committee decision about what we want to do with this bill, period. So if we could, I know we all have probably 85 million questions, but if we could move on to Representative McCann's bill, because she's ducking out of committee to be here. Let's walk through her bill. Stay tuned. More to come on this one. And after we've heard from what I would say to be like the key initial players, we'll decide whether we're going to try to keep moving forward with this bill now, later, or ever. I think those could be our three choices, or never. Never now. What are the choices? Never now, later.
I don't think we need it.
Please, those are our choices. All right. Maria, are you going to walk through?
I am.
Oh, great.
Oh, did you want to do that?
Yeah, I thought you were leaving.
No,
Great.
I was letting Representative McCann.
Oh, no. She already did her, she already did
I made
her,
my pitch.
her pitch.
That means.
Yeah.
All right, just bear with me one minute.
Don't hesitate this big. Thank you.
They want a hard copy?
Okay, Maria, thank you. That was very informative.
Great. So, H88, that could go.
Yeah.
Lights off as a temperature control measure.
I don't know.
Energy efficiency.
Energy efficiency, yeah, that's what I
Is that a request to have the lights?
No,
Because I could do that for you.
just curious.
I didn't even notice.
Okay. So, this will not take as much time. We're just gonna walk through H88. And this bill concerns utilities and a prohibition on disconnections during periods of extreme heat. It was modeled after a law that was recently enacted in the state of Washington. It applies to electric, water, and wastewater utilities. As you know, Vermont has consumer protection PUC rule with respect to disconnections during the winter months. Can't remember now if it's between November and May, but there's a period of time where disconnections cannot be made for non-payment. So involuntarily made for non-payment of a utility bill. There are other provisions that allow, if in the event, if a customer has some kind of a medical or health condition, it can also apply to be waived from any disconnection that otherwise might apply. Anyway, I just wanted you to kind of be aware of like existing rules that are out there. So this would be a new requirement. And there are two sections. As you know, the PUC has authority over all electric companies, but also over private water and large private wastewater companies. So the first section is basically requesting that the PUC adopt a rule, amends essentially their existing rule 3.3, to comply with what I'm about to read. The second section applies to public water and wastewater, which are regulated under, because they're municipal, they're not regulated by the PUC. They have their own chapter of Title 24 concerning disconnections. So that's why it's a little bit bifurcated. But with respect to the PUC's jurisdiction, the entities that it has jurisdiction of, PUC shall adopt a rule prohibiting an electric, water, or wastewater utility from involuntarily disconnecting residential service for non-payment during a period of extreme heat in the utility's service territory. For purposes of this section, residential service includes service to tenants in metered apartment buildings and residents of mobile home parks. The rule shall include the following provisions. A process that allows a resident to reconnect utility service during a period of extreme heat if their service was previously disconnected for non-payment. A process that allows the utility to require a resident to enter into a reasonable repayment plan prior to reconnecting service pursuant to subdivision 1. A process for informing residents of their rights under this section. A requirement that each utility keep a written record of all reconnection requests received pursuant to this section and all service disconnections rescheduled due to extreme heat. And those records shall be available for inspection by the PUC or the Department of Public Service upon request. And then in terms of what a period of extreme heat, there is a proposed definition in subdivision V1. Means that within 24 hours following the scheduled disconnection, the forecasted temperature is at or above 92 degrees Fahrenheit, or the National Weather Service has issued or has announced that it intends to issue a heat-related alert, such as an excessive heat warning, a heat advisory, an excessive heat watch, or similar alert. And then again, just clarifying that utilities are the utilities that are subject to the jurisdiction of the PUC. So section 2, again, this is the specific chapter on disconnections of utility service that are specific to municipal utilities, water and wastewater. So the amendment here, I will get to, let's see, sorry, I just need to go back and look at the lead-in language. So the disconnection shall not be permitted if, and then the new language here is, it's for delinquency and it would occur during a period of extreme heat, and then same definition of extreme heat essentially. And then subsection D is very similar, except it's stating in statute the requirements that allows a resident to request reconnection in times of extreme heat, and also allows the utility to require that the resident enter into a repayment plan before the reconnection, and then some greater specificity about that repayment plan. Again, this was modeled after the Washington law. It shall not require a resident to make monthly payments in excess of 6% of the resident's monthly income. Resident may agree to pay a higher percentage during the repayment period, but shall not be in default unless payment during this period is less than 6% of the resident's monthly income. If assistance payments are received by the resident after implementation of the plan, the resident shall contact the utility to reformulate the plan. And it takes effect July 1st. The rules, the PUC rules, believe that was pushed out to on or before June 1st of 2026. So that's when they have to complete their rulemaking process.
Could you go to the section about period of extreme? The definition, okay, yeah. So if I'm, just to make sure I'm understanding, so if it's a period of extreme heat, they can't disconnect for non-payment, or if you've already been disconnected for non-payment, you can request to be reconnected. And the period of extreme heat is defined as 24 hours, the whole 24 hours after. So if you're scheduled to be cut off at 3 o'clock on a Tuesday and it's 92 degrees that day, what if the temperature drops to 88 the next day?
Then you could disconnect the service on the next day. You mean if the forecast changes within that? How
I
would
guess
that?
I'm just having a hard time understanding the definition of, because this makes that the concept makes a lot of sense to me.
Yes.
That people need to be running their AC if it's really hot. So that I'm thinking especially of, I don't know, an older homeowner, right, who really needs the AC and it's really hot and you don't want to disconnect them during that time. And so I'm trying to wrap my head around a week-long period where it's 92, 88, 93, 89, 96.
Yeah.
So Washington must have dealt with that.
Yeah, no, it's a good question because so yeah, this thing you scheduled a disconnection and within 24 hours following the scheduled disconnection, that's the period of time that you look at. So then you would, if you said, okay, we can't disconnect because on Tuesday it's going to be 94 degrees, but we can disconnect on Wednesday because it's going to be 88 degrees if that forecasted temperature. So it depends on the forecast, but I agree with you in practice, like how fluctuations. But it's looking at what is the date that you're intending to disconnect and what is the forecast. So you would have to check the forecast 24 hours prior to doing the disconnection, I think, in any instance. And ensure that on that disconnection date, it's not going to be 92 degrees.
Rep Clapton.
So
I'm sorry.
the prohibition on disconnecting stays in effect as long as the forecast temperature for the next day, the high is 92. And that day when the forecasted high drops to 90, if the day after that it's not back up, then disconnect. And if it does go back up, you can call and say, reconnect, it's hot. Okay.
Oh, I'm sorry.
Oh, go ahead.
Can I, Representative
Go.
Campbell, I'm sorry.
Thanks. So first thing I'm wondering, and I don't know if he's said this, I'm suffering from extreme heat over here. If there's a parallel to cold weather disconnections,
There is.
is this basically follows that?
I think the cold weather, it's not tied to a temperature, it's a period of months. Maybe it starts in Vermont, starts in November.
Okay.
I might be wrong on the months.
Yeah.
Between the months of November and
Okay.
March.
It's good time.
Yeah, so you don't have the same kind of, what's the temperature today?
Right. The other thing that occurred to me is if this is based on Washington DC,
No, state of Washington.
state of Washington. Okay. Even so, 92 seems pretty high, and it might be that it would make sense for purposes of actually ease of administration for utilities as well as consumers to have a longer period than just 24 hours for good forecasting. That's just something we can talk about in detail. So,
Rep Southworth.
So just, I'm with you on the temperature timeframe. The process that allows them to reconnect service where they have to enter into a repayment plan, a reasonable repayment plan. It covers it for a period of time until they don't pay again, and then it would be disconnected. I don't think it's a daily thing.
Okay, that's
based
where I
on
was.
what I'm reading on the statute.
That's where I was bogging down.
can you say? Yeah, sorry.
Yeah.
So they have a process where they're required to enter into a reasonable repayment plan.
Yeah.
So with that, they're gonna get reconnected during that period of heat after they've entered into that repayment plan. So they're going to have some monetary payment to the utility company.
Yeah.
So the utility company has basically received a payment.
Okay.
So I don't think
They're in-
that
they're in
falls
a-
within a day. I think
they're in
they
a
have a
plan.
period of time.
Okay.
They're in a plan then.
Yeah.
If folks want to learn more, and then I see your hand. If folks want to learn more, it looks like the LIHEAP Clearinghouse, so the federal low income home energy assistance program. So LIHEAP Clearinghouse has a awesome, I just found it, hot weather disconnect policies by state. There's a summary chart, and then you can click on it, read their actual thing. Rep. Torrey?
I have a comment and a question. I guess I'll do the question first. So this is modeled on the cold weather. Is that true with the,
It's modeled on the Washington law. But it's
okay,
in concept similar to temperature.
okay.
Right.
I'm just curious about whether we have that in place for our municipal water and wastewater in the winter.
The winter disconnection? I don't know the answer to that.
Okay, so that part is only talking about.
The-
Yeah,
No,
I just wanted to,
that's a good point because so all of the electric utilities are regulated by the PUC, so you won't lose your power. Your question is, well, what about water and wastewater during cold months?
Exactly.
Is there any?
is there a
I'm
risk
not-
to the consumer?
I don't know. I'm not aware of anything that I can look.
And then the comment I had is, I think this is a great bill to protect people, but I'm concerned about the people who, because of cost, don't use their air conditioning if they have it at all, because they're afraid, they don't want to. It's not just being cut off, they don't want to bill. So I'm wondering if this could be potentially added to think about, something around whether the person is already enrolled in energy assistance, whether they are, could they be connected to weatherization? You know, because I feel like it's really important to reduce risk for folks, but we can't, if they don't even turn it on and use it out of fear of cost. It's still what's
Okay. So, yeah, Representative Bailey?
I guess I just wanted to add, correct me, and was this an issue last year? Or did we have a lot of cases that brought this to your attention?
So, a utility in Stowe just reached out with an email saying, that had some other information in it, but basically said there were 6 days in the Stowe area where we reached 92 degrees or higher. So I'm not sure how widespread over the state, but I do know in that one geographical section, there were 6 days.
Yeah.
According to that source.
And they needed to disconnect somebody during this time frame, or they were just looking for guidance?
They were just sending me data about
Okay.
how many days would have been impacted by this bill.
So it wasn't actually, there wasn't an instance where they had to disconnect someone in this realm. It was just data that they were providing to you.
Correct.
Okay, great. We, Representative McCann, thank you so much for being here. Yep, thanks.
Thank you.
We
Yeah.
don't have any additional testimony scheduled on this right now. We're gonna have to do some time management, about trying to figure out what bills we really want to try to get out, by crossover. And, I had a little panic realizing that we actually only have, a few weeks left. So,
To burn some juice.
all righty, thank you. So, we've got another bill to walk through. And then we'll be done for the day, for 4.
Mike, can I bug you again?
Absolutely.
Yeah.
Can I ask a question?
Yeah.
Some general question.
Yeah.
Have all of these bills been vetted so that there are no conflicting other statutes or rules?
Like the last 2 that I just went
Yeah, any
over.
that we go through, are they all vetted through? So there's no, it may be in a different title, it may be in a different rule. I just want to make sure that we are looking and making sure that we're not going to have conflicting.
I would say we all try to do that all the time.
That's your job.
I've seen that many times.
Yeah, I'm not aware of any conflict, but that's the beauty of taking testimony. Others with more expertise, subject matter expertise, if there are conflicts, they'll let us know. They'll let me know for sure.
Thank you.
But yeah, as far as I know, the disconnection, that was reviewed by the PUC. They'll come in and they'll talk about this, and I had the conversation with them. Would you prefer to do a rulemaking, or would you prefer to have it codified? And they actually prefer to do a rulemaking, make it consistent with their existing rules, but they can explain their position.
But at this point, we don't have further testimony scheduled on that bill. We can, but.
So I get confused. We make this, if we took this H88 and passed legislation on it, then they'd have to make rulemaking to propose it, but they may make rulemaking in the absence of this bill for hot weather. shut off or non-hot water. It's a non-shut off. It's not shut off. It's a non-shut off.
Like, would they do that without any legislation? I don't
Right.
know if they're considering doing that.
They could though, right? Is that what you're asking? Could the PUC do it without a bill?
Could they, yes, could the PUC, the same aspect of cold weather,
Yeah.
non-shut off, could they apply it without the presence of statute?
Right, that's a great question. And I'd have to look at their rulemaking authority, see how broad it is, but they do have authority, obviously, for consumer protection type issues. That's the basis of the winter shut off rules. So they may very well have that existing authority. But I don't know exactly.
Okay. Which 121?
121. I know you've already heard about this. I listened to the testimony from Representative Morrow. And as you know, so this bill concerns portable broadband service in the state of Vermont. And it's modeled after the law that was enacted in the state of New York. And as I mentioned earlier, was challenged in federal court and recently upheld by the Second Circuit in 2024, earlier spring of 2024. The industry trade groups that challenged the law filed a cert to the U.S. Supreme Court to see if the U.S. Supreme Court would review the Second Circuit's holding. The Supreme Court, the U.S. Supreme Court in December of 2024, just this past December, denied that petition for review.
Wow.
So no plan for review. That's not statement on the merits. It's just they're not going to review. And so the law stands. It took effect beginning January 15th. One thing that I learned recently, the petitioners or the plaintiffs in the case that are challenging the law recently, in January, a couple of days after the law took effect, filed a petition again to the U.S. Supreme Court to basically reconsider, like, would they think about changing their minds and actually hear the case? And the reason that they decided for doing that is because AT&T, just with respect to their fixed wireless service in Vermont, not their mobile cellular service, their fixed wireless service in Vermont, they said that they're going to pull out of the market in New York. And I don't know how big of a market share they have. But the other plaintiffs said, this is a big change in circumstances. Supreme Court, you're sure you don't want to, essentially, do you not want to hear this case and review? And that has not been decided on yet. But I just wanted to let you know that there's potential
Question. You said AT&T has fixed wireless
in New
in
York.
Vermont?
In New York.
Just in New York, not in Vermont.
I don't know what they have in
Okay, I
Vermont.
thought you said in Vermont, that's why.
Yeah.
Okay.
No,
They do? AT&T has fixed wireless in Vermont? I thought they pulled that all together.
I'll have to go.
Just to cover lines.
Department of Public Service.
Thanks.
I'll have to go look at it.
Yeah, okay. Thanks. I thought you said Vermont, which is good. Caught me here. Thanks.
in any event, so there hasn't been a decision on whether or not it's a final decision yet on whether the U.S. Supreme Court will actually hear and appeal. So, consistent with the New York law, this law provides that on or before October 1st of this year, an ISP that provides service in Vermont shall offer and provide affordable broadband service to eligible low-income consumers, and that is defined. In addition, in terms of what is meant by affordable broadband service, it means broadband that's capable or has a download speed of 25 megabits per second at a monthly price of not more than $15, inclusive of any recurring taxes and fees, such as recurring rental fees for provider equipment required to obtain broadband service and usage fees. And also, what's considered affordable broadband service is if the service has a download speed of at least 200 megabits per second at a monthly price of not more than $20, again, inclusive of any recurring fees. Broadband service is consistent with what we've reviewed and other definitions in Vermont, everything except for dial-up, basically. Applies to providers in Vermont. And then in terms of eligibility, go ahead.
So as this is written, would they have to offer both A and B or either one?
I believe it's either one. I think it's either one, but I'm gonna think about that as I'm reading through, because now I
Okay.
can't remember exactly how it was drafted. I think I'll find out. So to qualify, a low-income consumer means a household that qualifies for participation in the federal Lifeline program, based on criteria that are established by the FCC, or qualified for participation in the home heating fuel assistance program under Title 33. So the only things I wanted to mention about this. So under the Lifeline program, there's income eligibility. So if you make less than 135% of the federal poverty level, you qualify for federal Lifeline. And Vermont Lifeline is the same. There's a Vermont subsidy, same criteria. The Vermont subsidies basically piggybacks on to the federal. So for Lifeline, there's an income threshold. I believe it's if you make less than 135% federal poverty level. There are also what are called categorical eligibility. So if you participate in SNAP, Supplemental Nutrition Assistance Program, and then there are other programs that are also referenced, assistance type programs. The reason why I mentioned SNAP in particular is because the income threshold to qualify for that is 185% of the federal poverty guideline. So technically, if you make that higher threshold, if you participate in SNAP, you can qualify. It's confusing. There was a lot of discussion about the eligibility requirements, because as you can imagine, under the Lifeline program, the existing program that applies to voice service and now at federal level voice and broadband, trying to confirm whether somebody is eligible was somewhat burdensome and problematic. So the federal government created the National Verifier System or database, where basically states report data to this one database about who's enrolled in all of the specific federal and state programs that qualify for eligibility. And it was meant to streamline things, minimize any fraud or abuse, etc. But I just mentioned because it always comes up as what's the burden, what's the administrative burden, figure out who qualifies. So there is a national verifier database that providers and consumers can apply through an application. And anyway,
is SNAP related to that? Is that why you brought up SNAP
I brought up SNAP because yes, SNAP is one of the categorical
for that registry?
for federal Lifeline for that registry.
Yeah. Because
And
SNAP's not mentioned here. at all.
It's not mentioned here, but it's if you qualify for federal Lifeline, if you're enrolled in SNAP
Yeah. Oh, the federal,
for federal Lifeline.
like, okay.
Yep,
Jump in here for a second.
Yep.
You qualify for federal lifeline, you qualify
for state Lifeline, and you qualify for this.
So I sent around that Xfinity has a plan.
Yeah.
Basically that does this. I sent you around the details. For their qualifier, they just need one or to be eligible for Medicaid, public housing under HUD, SNAP, temporary assistance for needy families, SSI, Head Start, LIHEAP, WIC, Federal Pell Grant, VA pension, or tribal assistance eligibility letters. So she's very tempted if any of those programs, then you're eligible for their,
Okay.
that's just,
Jack, did you post, that, or could you post that with today's testimony piece from Chris Redfarm?
Which one?
He'll send it to you.
it was, I sent it to the whole house. Do you get, our committee emails?
I actually don't get those.
Oh, you sent it to the whole house?
Not the whole house.
Oh.
The house.
Wow, go and get it.
All right, I was sending you that.
Okay,
It's getting a cutback.
great.
We're taking this up, right?
All right.
It's out there now.
Okay, sorry. Back, focus.
Focus. Okay, thank you. I am focusing. So getting back to more of the initial question. And I realize it's in subsection A. So beginning in October, an ISP engaged in the broadband shall offer and provide affordable broadband service to low income. Because affordable, there are two definitions. I think that answers your questions, either or. Okay. So then, there is a rulemaking provision in subsection C. The PUC shall adopt the rule of following provisions: the time and manner in which the price is established in the definitions of what constitutes affordable broadband may be adjusted to account for inflationary changes as measured by the CPI, Consumer Price Index, but in no event may the monthly price be increased by more than 2% per year. New York was a little bit different. It's specified for like 5 years. You can, that might be something you wanna, but giving it to the PUC to kind of work out some of the details, because there are other provisions in New York that also refers to their PUC. And so this is just saying, okay, any of the specifics that are necessary maybe should be considered in a rulemaking process. So in addition to whether and how to adjust those prices, $15 and $20, the PUC will have rules on standards and procedures for waiving upon a provider's request, the minimum speed requirements in subdivision, that's the $15 of this section, but only if the commission determines such download speed is not reasonably practicable under the circumstances and specifies an alternative minimum download speed. Also, as part of the rules, standards and procedures for exempting a provider from the requirements of this section if the providers provide service to not more than 20,000 customers, that was the New York threshold, and the commission determines compliance with the requirements of this section would have an unreasonable or unsustainable financial impact on the provider. Also, provisions in rulemaking that ensure that any contract for service entered into under this section has the same terms and conditions other than the price and speed as their regularly priced offerings available. And then subsection D, beginning in November, all ISPs, broadband providers shall submit to the Department of Compliance report, which includes the following description of their broadband service offered pursuant to this section, the number of customers receiving affordable service, a description of the procedures used to verify customer eligibility, a description and samples of the advertising or marketing efforts undertaken to advertise or promote the service, a description of all retail rate products, including pricing offered by the provider, and a description including speed and price of all products offered in Vermont, the number of customers who are in arrears for broadband service, the percentage of those customers who might qualify for affordable service under the statute, those who have had their service terminated for non-payment or terminated for arrears arising from non-payment for services other than broadband service, such as voice, the number of customers that have had their broadband service restored after being delinquent on their payments, and any other information deemed necessary. And then subsection E just says, beginning in October of 2027, not less than every 5 years, the commissioner shall undertake a proceeding to determine whether the speeds should be updated. Higher thresholds, and also review the eligibility requirements, whether those should be updated to meet the needs of customers. And then subsection F is an annual reporting requirement to the General Assembly by the Commissioner of Public Service, which would start in December of 2026. Basically providing a description of all the aggregated data that they've received from all of the individual company reports, and any recommendations the department has on increasing the speed, or the eligibility requirements, or any other findings and recommendations. And then G basically is just a requirement that the provider shall make all commercially reasonable efforts to promote and advertise the availability of affordable broadband service. And goes on to say, including the prominent display of enrollment procedures for such service on the website, provider's website, and in any written and commercial promotional materials developed to inform consumers who may be eligible. The department can also engage in outreach efforts to inform the public. And any violations of this section constitute a violation under section 2453, which is the Consumer Unfair Business Practices chapter. This referencing back. And a provider who willfully and knowingly violates a provision of this section is liable for a civil penalty of up to $1,000 per violation. Yeah, takes effect on passage.
So question for Maria or for Representative Morrow. So, Chris, you were saying in your, or Representative Morrow, you were saying in your letter to all of us that this plan already exists for, no,
Xfinity,
for Xfinity?
more or less, yeah. It's pretty much, they have 14.95, I think it's 75. I think it's 14.95 all inclusive, and I read you the eligibility requirements, and so not, obviously no reporting or any of that's happening, but clearly this is economically viable for a major company to do this without, they see it as an asset of them.
Yeah.
I'm sorry, I apologize if I missed this. Are the other incumbents part of this?
Video.
Yeah.
All providers.
All, oh. So isn't there a 20,000?
If you meet the
customer
threshold, yeah.
So of the other
Oh, so
local,
who,
of
what
the-
provider?
I'm wondering who would apply
This would
to.
Yeah.
be Fidium, I think is the only other one.
Yeah, I don't know.
Like
Who makes-
Mansfield,
Yeah, I don't know what the customer.
Actually, nobody.
Maybe charter.
I really don't want, I don't want to get, because I probably off.
Okay,
Yeah,
Rep. Corey?
I'm just curious what that 25 speed means. Like, is it good enough for email? I mean,
Yeah, that,
you
I
know,
think
what
that should-
value are they?
That should go up a little bit. Yeah.
And I think that's New York, but New York's law was enacted in 2018. So I didn't really, they may,
Yeah.
something to consider,
Yeah,
because
I
at that
have something
time,
on
that
that
was
too.
considered broadband under the FCC's definition of high-speed broadband, but now it's 100 download.
Right.
So,
Yeah, Rep. Kleppner.
Do we know how many of the people who would qualify for this do not have broadband because of cost, and how many do not have it because of lack of access?
I do not have that. It would be nice if we could find that data during testimonies.
So there is data some data available. So there's data available about the number of Vermonters that have the federal lifeline program, right? So they meet those income thresholds and they signed up. Not everybody signed up. And I think the most recent data I had, there were about 10,000 Vermonters signed up for the federal lifeline program.
Statewide.
Mhm.
Statewide.
Statewide. Yep. But you should get updated. I'm just letting you know,
Yeah.
like there, that information is available. In terms of, so all of those individuals, whatever that number is, also qualify for the Vermont Lifeline because that's just a supplement to, but there are far fewer people that take advantage of the Vermont Lifeline because that's only for voice. So not everybody wants a voice service, right? They might just have.
I'm sorry, what did you, the 10,000 is who then?
That's roughly the figure of Vermonters that qualify for the federal lifeline subsidy for broadband, right? There's a federal subsidy,
Okay.
right? And you'll get updated numbers, but I'm just giving you a ballpark and letting you know that these might be helpful.
Yeah.
The other thing that I wanted, to mention, there's, as you know, there was the federal affordable connectivity program that was a pandemic program that was funded and then ran out of money. That also provided a broadband subsidy of, I think it was $30 a month. The eligibility was a little bit higher. It was 200% of the federal poverty guidelines. What we do know is that about 25,000 Vermonters qualified for that program. So that gives you some, again, I'm just trying to throw out some numbers and information that you can get and confirm.
So,
Mhm.
so that program is different. I mean, that was providing a subsidy to people.
Yeah, I'm thinking of more of the eligibility, but yeah, very different.
Very different. And some would say, like me, a subsidy to the for-profit companies. Yeah.
Questions? Okay. Maria, thanks for spending so much time with us.
My pleasure.
Really appreciate it. Super informative. Let's have a brief committee discussion. And then, report. Okay, so, I just wanted to talk a little bit about timing. Because time flies when you're learning about issues and taking 101 testimony. So we've got 3, not including this week. So this week, we've got a lot of testimony packed up on H11. And I think that we'll probably be able to decide at the end of the week what we're going to do about that bill. And then next week, I am trying to load up the docket with testimony on our Agency of Digital Services bill. We really, at this point, only have 3 people that I think we need to hear from. So we're going to reach out to Lisa Govin, our JFO independent consultant, obviously to ADS, to get them in and see what they think of the bill. And then maybe have the deputy auditor back in. So that bill is, we'll be walking through it tomorrow. It's not particularly complicated. And so depending on what we hear from our witnesses, we can move it forward or not. But our bills have to be voted out of here by March 14th, and we've got 3 weeks left to do that. So there's the ADS bill, and then H125, reporting on the energy transition. We are going to take testimony on that as well next week and see what we think about that bill, whether we like it, and whether, if so, whether we can get that voted out by March 14th. And then we have to do our budget memo to approbes, which I'm thinking might not be super time consuming. I'll forward everybody the letter from approbes for us all to look at. But if there's truly nothing for us to consider on the energy side, it really just comes down to it might just come down to the ADS budget request. And we can hear from Representative Campbell on that. We can have Representative Harrison come up and we can hear from ADS on that. So that may not be particularly time consuming either. So are there bills that we've heard about so far, walkthrough bills, that as a group we feel urgent about taking up and trying to get out before crossover? Besides the ones I just mentioned, which are high on my list. Yeah.
I don't know if Pete's latest bill on that we just heard about, which I was listening to, maybe for consideration with 125.
Attach it.
Yeah, I don't know if that works.
I don't either.
And I don't know how complicated the testimony is that we need to get.
It could also fit in a miscellaneous PUC. Are we gonna get one?
I don't think so.
No.
Yeah, I mean, we had a request. There are a few little housekeeping things that PUC would like us to take a look at. They didn't feel urgent to them.
Oh.
And so it didn't rise, to be honest, it didn't rise to the top of my to-do list. So are folks having initial thoughts on, oh my God, we got to try to move this bill? Besides, H11 will wrap up all of our initial testimony this week and decide, H11 is a big bill. That could be like a 2-year project. I don't know what you're thinking. The reporting on the energy transition, I feel is an important bill because I think it starts to get us the kind of data that we talk about all the time about how are Vermonters really feeling the energy transition.
I have more questions than feelings on all of them.
Yeah, like that's often the case. And our ADS bill, I guess we'll see. It's very important that we hear from ADS. So I guess I would just say, we can adjourn, get back to me. Let me know what you think. But March 14th is our drop dead to vote bills out of committee. And I don't think any of these have money attached to them. Right?
Well, that's one of my questions on the fuel one, so I want to get into that discussion at some point.
Yeah.
Because some of them, to me, have the appearance of costing money, and I want to know the answer to that.
Okay. Yeah, that's actually important because it impacts our one, our budget letter, and 2, it impacts our
Deadline.
our deadline. So, okay, great. I guess I would say then, Rep. Southworth, which bills are you wondering about if they're gonna, probably 125, right? Like whether DPS is gonna request.
There's a number of them that I have concerns about costing.
Okay. H11 as well, maybe.
Every one of them, if there's an oversight and a report or something, that has a $ attached to it because it means more work for somebody somewhere.
Right. And sometimes
That's a broad answer to you.
Yeah, no, that's good. That's important because sometimes they absorb it and sometimes they come back and say, we can't do this unless you give us X, Y, and Z.
Correct.
So, all right. So we will get next week stacked up with H125 and our ADS bill. That's draft 250896, and that'll be posted. We all have it in our inboxes. So, okay, great.